All right. Hi, everyone.
Hello.
Welcome. Attendance is a little bit thinner. I trust that's due to the flood and not the reading. But if it is, they're missing a good show. So the class today will be a little bit different. As you may have guessed based if you watched last year's video. The topic today is the Affordable Care Act case, NFIB versus Sebelius, which I wrote a book on some years ago. So today will be unique in that I'm going to be lecturing primarily. I don't like doing this, but for this, it's a better show. Because I've given this talk probably 100 times at this point. I can do it in my sleep. In fact, I've written a subsequent book about Obamacare, and I usually give this talk twice a year when I teach ConLaw, so it's good to keep it fresh. The case of NFIB versus Sebelius, decided in June of 2012, is a crowning jewel of your study of federalism and the separation of powers. If I could imagine a single case that brings together every single theme you've studied so far, this is it. And a case that presents two diametrically opposite views of these topics, this is it. And a case that is at the center of law and politics in a way that most people don't even begin to understand. It's this case. If any of you want to read the book after the semester, I encourage you to do it. I gave you a free chapter. Buy the rest, as they say. So the story of the Affordable Care Act is truly a clash of all three branches of our government, between the presidency, between the Congress, and of course between the Supreme Court. And this was a clash over the Constitution itself in the form of health care. Now, I don't want you to get too bogged down in the details of health care and health insurance, but I'm sure as many of you are aware, this has been a long simmering problem in our country, the question of how to provide health care for people at an affordable cost. We have a new law in effect now. We can debate later how well it's doing. But leading up to the 2008 election, this was a pretty big issue. Now, one of the most significant efforts of reforming health insurance occurred before many of you were born. Does anyone in this room recognize this picture of what this represents? Mm-hmm. Yeah? Mm-hmm. Tell us.
Well, it's President Clinton and Hillary Clinton.
It's true, that's who they are. And what do you think this picture symbolizes? What are they announcing here?
Hillary Care?
Hillary Care, good, thank you, yes. So in 1993, after President Clinton was inaugurated, he appointed his wife to chair a task force to reform health insurance in the United States. The United States is somewhat unique in the entire free world, in that it does not have a universal form of health care. We have government-provided health care for the elderly, what's called Medicare. We have government-provided insurance for the sick and the disabled, that's called Medicaid. But the overwhelming majority of Americans, to this day, receive their health insurance not through the government, but through their private employer. Hillary Care was a proposal where every American would have had one of these little cards called the Health Security Act. This is what the law was called. And it would give every American health care. It's a little bit complicated, I'm summarizing. It was not single payer, that is, there was still private insurance, but every American would have had an opportunity to acquire government health insurance. This bill did not pass in large measure because of a series of commercials that aired throughout the 1993-94 season. Depicted Harry and Louise, a ma and pa sitting around the table at home, reading this big book. There was no internet back then. They're reading this big book about this new health care bill. And they said, you know, I don't want this new health care bill. I like my doctor. I want to keep my doctor. I don't want the government getting between me and my health insurance. These ads were so effective that in the span of a few months, the popularity of what became to be known as Hillary Care, the popularity tanked. And in no small measure because of this defeat, the Republicans took the House in the 1994 midterm elections. And with that, Hillary Care was dead, or at least for another 12 years or so. Instead, the task of reforming health insurance fell to the 44th president. That's our 45th president, Barack Obama. Okay? 44, sorry, can't count. And even though healthcare was not the major priority on the campaign trail, it was usually the economy or the Iraq War or Afghanistan, President Obama made it his mission that in his first term, in his first 2 years, he wanted to enact healthcare reform. And this took the form of a law, which you've read at least one sentence of, called the Patient Protection and Affordable Care Act of 2010. Now, I don't want to bother with all the details of the law, but there's a couple provisions that are going to be very relevant for our discussion. One of which is the individual mandate, or as it's called, the minimum essential coverage provision. And this provision requires people to buy health insurance. Now, if you're too poor, or if you're on government-provided health insurance, or if you have a qualified plan through an employer, you're not subject to this mandate. But if you're able to afford health insurance and you choose not to, you have to pay money to the government. How to characterize those payments is the subject of the case. Notice I said money, I didn't say a tax or a fine, we'll get there later. The second provision of this law that you need to be aware of is what's called the Medicaid expansion. Now, students often don't know the difference between Medicaid and Medicare, and I did not know when I was in school. Medicare applies to seniors, and you can remember that because there's an R in it, like retired. Medicare is for seniors. Medicaid is for the poor, the disabled, and other destitute people. The way Medicaid works is that it's administered by the state. And the federal government gives money to the states, and in turn the states provide care to certain poor people. Now, one of the odd things about Medicaid is it looks different in every state. As you can imagine, it's state-run. So even before the Affordable Care Act, in some states, people at the poverty line were able to get Medicaid. In other states, people at 60% of the poverty line were able to get Medicaid. And in other states, people at 30% of the poverty line were able to get Medicaid. In addition to who was eligible, the level of quality care differed. Some states gave much more care than others. The Affordable Care Act sought to change that. The Affordable Care Act said we want all states to have the same level of Medicaid coverage. This is what's called the Medicaid expansion. They want to expand it. And they said if you are at 133% of the poverty line, make it easy, let's say the poverty line is $10,000 a year. So if you make $13,000 a year, you'd be eligible. So if you're at 133% of the poverty line, you're going to be eligible for a full range of health insurance, a very comprehensive set of benefits. And what happens if you, state, don't want to oblige? Well, the government stated this in a letter to Arizona. They said, if you don't expand your Medicaid, we're not only going to hold back the new funding, we will bankrupt you. We will take away every penny you get from Medicaid. Now, in most states, Medicaid is going to be 10, maybe as much as 20% of the budget. If you tell a state we're going to cut 20% of your budget, they don't have much of a choice there. So you have these two provisions. You have the individual mandate, and you have the Medicaid expansion. That is what's at issue in the case of NFIB versus Sebelius. There are other Obamacare cases. You might have heard of the Hobby Lobby case. You might have heard of Little Sisters of the Poor. You might have heard of King v. Burwell. There'll be cases forever about Obamacare. But those cases did not concern the core constitutional challenges, right? So were these provisions constitutional? Now, if I had asked you this question in 2009, say I was your ConLaw professor back in 2009 when this law was being debated, my answer would have been, yeah, they're constitutional, right? Of course they're constitutional. Congress can regulate economic activities that have a substantial effect on interstate commerce. Health insurance is a big industry across state lines. People go from one state to the other to get treatment. Of course, Congress can regulate it.
I have a question.
Yeah.
Did y'all talk about the constitutionality of this while you were in law school?
Did I? Well, to date myself, I graduated law school before this was an issue.
Right, but I thought you said you graduated in 09.
Hypothetically, if.
I mean, but I mean like.
Well,
Did
can I tell you a story?
Yeah.
Let me tell you a story.
Sorry.
So, if you had been a constitutional law student, I graduated law school in May of 2009. I'm ancient, I know. In the fall of 2009, November, I was at a conference. It was a Federalist Society conference in DC. And the Federalist Society is a group of conservative and libertarian lawyers that usually conspire, and they come up with various chicanery to take down the administrative state and the like. This day was no different. So I was randomly wandering through the hallways of the Mayflower Hotel, and talking to people, schmoozing, doing what I usually do. And I came across a couple lawyers. I told you their names, you wouldn't know them, but one was Todd Graziano, Andrew Grossman, Nelson Lund, and they were talking about this new healthcare bill, right? And they were saying, how can the government make you buy health insurance? And one of the lawyers, Todd, said to me, Josh, you're a young blogger, right? On a blog. You're a blogger. What do you think? I'm like, well, Todd, Congress can regulate economic activity that has a substantial effect in interstate commerce. Insurance is economic activity. Even if you buy insurance in one state, it spills over to other lines. Maybe you need treatment. You aggregate it together under rates. This seems pretty good. See, I wasn't thinking smart enough, right? I hadn't read Gonzalez-Urach close enough, and you all have. So remember I made a big fuss about the word economic activity. Economic activity. I kept saying, it's like, why is Blackman harping on economic activity? What is being regulated with the Affordable Care Act? So the argument came about not by Harvard law professors and really smart people, but by people you've never heard of, right? And there was a law student who went to Case Western, who wrote a note, a law review note, studied Gonzalez-Urach, and he said, well, Congress can regulate activities, but what about inactivity? What about not acting? They make you act. And when he wrote that, no one really cared, because it didn't really matter. But then when Obamacare came around, I was like, oh, that matters now. You see, you guys have to think outside the box. The same way that Lopez's public defender thought, I got an idea, let me challenge this on Commerce Clause grounds, right? Let me just throw this out there. And he won. He got his client off jail. The same token here, people consider the Affordable Care Act is not like past laws. It's not merely regulating economic activity, they argued. It's compelling you to engage in activity. That it is a regulation of inactivity. And this was an argument that literally germinated in a few weeks in response to the ACA. And I happened to be there at the genesis. I called it the Mayflower Compact. It was at the Mayflower Hotel. It's a good chapter in my book. But over the next few months, this argument germinated. But it's not enough to have law professors and lawyers make arguments. No one really cares what we think. There has to be an acceptance of this argument in society. And that's why I say this is not merely a legal case, but a case of law and politics merging. And at the same time, right, at the same time that the Affordable Care Act was going through Congress and constitutional lawyers were screaming about regulating inactivity, a social movement was developing. This was the Tea Party. We don't hear much about them anymore, but they were quite prominent back in 2009 and 2010. And their grievance, if you could summarize it, was against the federal government in general. But one aspect, or one plank of the Tea Party, was Obamacare and the Affordable Care Act. And they were very much opposed to it. And not just because they thought it was bad policy, I'm sure they did, but they also argued that it was unconstitutional. And the reason why they thought it was unconstitutional is a very natural sentiment. The government can't make me buy something, right? If I were to explain to you the Wickard principle, it would take me maybe 5 minutes to explain it. right? If I want to explain to you the government can't make you buy stuff, oh yeah, I agree, right? That takes like 5 seconds to explain, and people can natively understand it. And this grew up over and over again as the Tea Party grew and grew and grew. In fact, I was in D.C. today. I have a habit of being in the wrong place at the right time. You know, I was in Charlottesville, I had the eclipse and everything else, right? I'm always in the wrong place at the right time, or the right place at the wrong time. So I was actually in D.C. by chance the day, March 23rd, 2010, when Obamacare passed the House. And I was walking around, and there was this massive Tea Party rally. I saw John Boyd, whatever it's worth. And I saw one guy in a T-shirt. I wish I took a picture of it. It said, "Overturn Wickard v. Filbert." He had a T-shirt. Overturn Wickard v. Filbert. Can you imagine? I didn't know what the hell Wickard was before my second year of law school. But anyway, so there was a very strong constitutional current in the Tea Party. There's lots of other stuff, and we can talk about it another time, but with respect to Obamacare, there was a constitutional current. The idea was, the government can't make me buy stuff I don't want to buy. Okay? But at the time, the objections were just that. And the Democrats had the votes. In the election of 2008, the Democrats secured 60 votes in the Senate. And as a consequence, as long as they remained united, they could defeat any Republican filibuster. Senate Majority Leader Harry Reid recognized the Republicans were not going to support the bill at all. They thought they may, and there was some flirting with it, but didn't go very far. So Reid decided that he would try and pass a vote on a party line basis, straight 60 votes. So the actual bill, the Affordable Care Act, the final version, was released in December of 2009. And the actual bill was about 3,000 pages in length. And the House said, we are going to vote on this Christmas Eve, December 24th, 2009. That way we can vote, and go home and be merry and jolly. Did anyone actually read the bill? Of course not. Senator Baucus, who chaired the Finance Committee, admitted, I pay people to read the bill for me. So no one actually read the bill, and in fairness, no one read the current health care bill either. This is a difficult and dangerous way to govern. But no one read it. Amber?
Well, I just was wondering, that's, it was online, right? It wasn't, ever a printed copy, right? Is that?
I think this picture is a printed copy. That's about how tall it is.
Oh my gosh.
So, yeah, it's basically, about 3,000 pages. So, your textbook times 2, just to give you a sense. But government, they don't read bills, either party, so it's all good. So at the time, December 24th, 2009, on Christmas Eve, the bill is passed on a straight party line vote. 60 Democrats, 39 Republicans, one had abstained. I think he was out of town on illness, but didn't matter. That bill that passed in December of 2009 was never meant to be the final version of the bill. The plan was, let's pass something in the Senate, send it over to the House. Let the House do what they actually need to do, bring it back to the Senate later, and we'll approve that. The Senate wasn't really concerned about the details. They were letting the House drive the debate. It was a little bit more progressive. But there was a problem with the strategy. Over that summer, Senator Ted Kennedy of Massachusetts had passed away. He died that summer. And he was the Democrats' 60th vote. Now, the governor of Massachusetts put in someone temporarily, a Democrat. But a special election was held in January of 2010. And who won that special election? Our current ambassador to New Zealand, Scott Brown. He won as a Republican to represent Massachusetts. He ran on the platform of being the 41st vote to stop Obamacare. That was his campaign promise. He said, I will stop Obamacare. And with that, the Dems lost their 60th vote. So what is then the consequence of this? Well, if the bill was brought back from the House to the Senate, it would have been killed by filibuster. And there was a brief period where President Obama said, we may not be able to do this, right? If we're banking on 60 votes, and we don't have 60 votes anymore, they had 59, we have to drop this. But they figured out a way. So Speaker Pelosi in the House said, okay, I'll tell you what. We're going to take the Senate bill and basically pass it as is and make some changes that affect the budget, but nothing too big. And as long as they're able to make very small changes that are budgetary, the filibuster is not applicable. This is what's called the budget reconciliation process. So John Boehner, who was the House Minority Leader, the Republican leader, could do absolutely nothing to stop this. Amber, if you want to get a sense of scale, that's the scale of how many pages we got. But I think someone did actually print out 3,000 pages. It's like 6 reams of paper, I guess. But the bill passed. Amending the bill by passing is confusing. But in any event, they were able to cobble the votes together. And on March 23rd, 2010, that was the day I was in D.C., the House passed the Affordable Care Act. And this was the vote breakdown. I want to dwell on this for a minute. If I do put it, I make like a 0. Not a single Republican backed the law. And in fact, 34 Democrats voted against it. The final vote was 219 to 210. And there are a lot of different ways to look at this. So the one way, which I think is the obvious way, is that the Republicans were not at all interested in health care reform, which is absolutely true. They were not in any sense going to give President Obama that legislative victory. They wanted no part of it. The other way to look at it is, historically, big legislation is bipartisan. The Social Security Act, the Civil Rights Act, the Americans with Disabilities Act, any major piece of legislation in the 20th century, at least, that passes, was done with both sides of the aisle. Obamacare wasn't. It was pass it on a straight party line vote and hope everyone gets in line. So the current acrimony, the current tension over health care is not caused by this vote, but that vote is a huge contributor to it. And I think that it, in large measure, implicates, right, how our society works. If there's such bitter disagreement at the outset, it's unlikely that people will come together later down the line. I think that's exactly what's happened over the last couple of years. So the current dissenting views on healthcare, I think, stem in large part to that big 0. And likewise, if a new healthcare bill is passed in the next month or so, it'll be the exact same thing, the opposite, right? With all Republicans on one side and all Democrats on the other. Not a recipe for success. In the event, the bill goes to the White House for President Obama's signature. And if you look closely, see all these pens over here? You know why they're all there? The president actually signs his signature with 23 separate pens, right? So each stroke is a different pen. That way we can hand them as gifts. Oh. So it's like a commemorative item. If you actually look at the signature, I'll show it later, it's very broken. It's like da, O, 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 B, new pen for every stroke. He hands them out. So they say, I have the pen that was used to sign the Affordable Care Act, you and 20 other people. Well, that's the tradition. And you can imagine President Obama signing this, he's smiling, he's happy, he's like, yes, the battle over healthcare reform is over. Not so fast. Within, I think it was 10 minutes of the president signing this document, this law, lawsuits were filed across the country. You see, long before people sued Trump, they sued Obama. You know, there's really nothing new. So within minutes of this law being signed, constitutional challenges were filed across the country, contesting both the law's individual mandate and the law's Medicaid expansion. And the question was the mandate constitutional? Did Congress have the power to impose the individual mandate? Now, you all know about Wickard v. Filburn, right? This was the case with a farmer, and it established the rule that if you have an economic activity, even if it's intrastate, if you aggregate all those different economic activities together, and there is a substantial effect on a substantial effect on interstate commerce, Congress can regulate it. This was, the court said, the furthest reaching extent of the Commerce Clause, right? Because you can take local activity, and if Congress imagined some rational basis that if you add up all the little farmer Filburns, you get interstate commerce. Is this case governed by Wickard, right? Is this within the Commerce powers? We also have Raich, right? Gonzalez v. Raich. Here we have locally grown marijuana. The majority opinion by Justice Stevens says, well, growing marijuana is an economic activity, because Webster's third dictionary told us it is. Therefore, we can aggregate it together. But then there was Justice Scalia, who I had the coherent opinion. Scalia wrote, forget about the Commerce Clause, right? This is necessary and proper. If Congress has the power to regulate a broad scheme, a national regulatory marketplace for drugs, they need to go after local weed. Because if you can't regulate local weed, then the entire market falls apart. Now, Raich was argued by Randy Barnett, who is my co-author in the textbook, and before that he wrote the foreword to my first book. So Randy had a fairly good understanding of the Raich case. And at that very moment, I mentioned the Mayflower Hotel, Randy walks in. He's something like a little rock star in our own little world. And he's approached saying, hey, Randy, what do you think about this Obamacare thing, right? He said, well, I haven't given it much thought. That was his quote. I remember it like it was yesterday. I haven't given it much thought. But over time, Randy and others developed the arguments about why the Obamacare mandate was unconstitutional. Okay? And you can summarize it in a very famous cover of Reason magazine. It's a libertarian magazine. And if you read Justice Ginsburg's dissent, which you were supposed to, she made a big point about broccoli. Can the government make you buy broccoli? Well, it's not going to make you eat broccoli. Let's get this straight, right? Can they make you buy broccoli? If they make you eat broccoli, it's different problem. I don't eat broccoli anymore. I used to actually like it. I gave up broccoli because of Obamacare. I'm serious. Whenever I look at broccoli, I think of John Roberts. I get this sick taste in my mouth. I swear to God, it's true. I don't. Ask my girlfriend. It's true. I will not eat broccoli. I can't. I think of John Roberts. I get sick. So anyway, I'm good enough with that. George H.W. Bush doesn't eat broccoli. I'm in good company. In fact, George H.W. Bush, right, banned broccoli in Air Force One. He said, I am the president, and I'm not having broccoli on my plane. Amen, George. So, can they make you buy broccoli? What's the argument? Well, if people buy broccoli, maybe they'll eat it. And if people eat broccoli, they'll be healthier. And if people are healthier, they'll have lower healthcare costs, and we can drive down the national marketplace. That sounds a lot like heaping inference upon inference upon inference from Lopez, right? If we have guns in schools, the kids won't study good and they won't learn good and everything else, right? But there's a more fundamental problem beyond can they make you buy broccoli. And this is the point that most law professors missed. We only get to Lopez, right, if we have some sort of economic activity, right? If Congress doesn't establish as an economic activity, we don't start aggregating. We only aggregate with an economic activity. This is why Rehnquist's opinion was wrong, right? Once you say that carrying a gun is not economic activity, you don't go into the aggregation principle. Someone asked me, it was Zach, someone asked me last week, I can't remember who it was. But if you say that we don't have an economic activity, you don't go to aggregation. So I think Rehnquist was actually wrong. Close enough, but wrong. But the question is, if Congress has an economic activity, what can they do to it? Can they make you buy broccoli? Can they make you buy a car? Like imagine years ago that General Motors was basically in federal receivership, was owned by the taxpayers of the United States. Can they say, you know what, we're going to make everyone buy a GM vehicle to get Detroit back? You know, we stole Verlander for maybe get something back in return, right? Can Detroit get something back that'll make them buy some Chevys, right? This was the question. Anyway, back to the, see this, by the way, this was his signature. So you see the O is very like jagged. That says like 1 pen, 2 pens, 3 pens, 4 pens. He used like 6 pens to draw the O. And the line is like another pen, and the B. You can see it's very jagged. The reason why he uses different pens. Apparently he got much better at it later in his presidency. This was fairly early on, but he got practice. So the question is, does the commerce power allow the government to impose the purchase mandate? Okay. But there's an alternate argument, though. what did we say in Scalia's opinion if it's not an economic activity? We go on to the necessary and proper clause, right? This is the framework. You first ask yourself, is this an economic activity? If so, you check if there's a substantial effect. But if it's not an economic activity, you ask, necessary and proper, is this part of a broader regulatory scheme? So this is why the mandate was needed, and this is maybe not clear from the case, but I'll explain it to you. Under the ACA, it was now illegal for insurers to charge people more money if they were sick. This is the famous pre-existing conditions law. But there's a problem with this pre-existing conditions law, right? Think about it. If you're in their shoes, if you can buy insurance literally in the ambulance, right? Say you get hit by a bus, you take out your iPhone, and you're buying insurance while you're in the ambulance, and they can't charge you more because you're sick, right? You're gonna make out like a bandit. And then the second you get your surgery, you cancel your treatment. So this has happened in states where they've imposed this pre-existing condition regime, where people basically took advantage of the system. They said, screw it, I'm not buying insurance so I get sick, right? You get diagnosed with cancer, okay, I'll buy a policy now. Give me $100,000 in chemo, and I'll drop my policy. So the mandate was designed to prevent this exploitation. Because what would happen is this. People would not buy insurance. The only people in the marketplace are the sick people. Healthy people would stay outside. That raises costs, raises premiums. And then as the premiums go up, more people drop out of the marketplace because it's too expensive. And premiums go up and more people drop out. This is what's called a death spiral. It sounds like a metal rock album. It's called a death spiral. And it destroyed healthcare markets in a number of states. So Obamacare said, we're not going to let that happen. We're going to make you buy insurance to prevent that death spiral from going out of control. That's why the mandate was needed. So the argument was, even if Congress can't make you buy insurance, in order to let this broad marketplace work, where we don't have this death spiral, we need to then mandate you. Let's say it again. The argument under necessary and proper is that to make this get what's called guaranteed issue, right? We guarantee you an issue of policy. In order to guarantee pre-existing conditions, we can't have people taking advantage. So we're going to make you buy insurance. So even if making you buy insurance is not an activity, even if going uninsured is not an economic activity, under necessary and proper, the government says we can make you buy it to prevent the death spiral. The same way in rates, you have this nationwide drug market. It's part of a broader regulatory scheme. So the question is, can Congress sweep within its necessary and proper powers this great authority to make you buy insurance? And those of you who read the case know the answer, but I'll get to later. There was a third argument involving the taxing power. Now, I don't teach you much about the taxing power except for this case because it doesn't come up very often. But Congress established very early on that even though its power to regulate is limited to interstate commerce, it can tax local stuff. So if Congress wants to put a tax on lottery tickets, or they want to put a tax on liquor, they can do that. The taxing power is much broader than the commerce power. They can tax purely local conduct. The problem with this argument, though, is that the Affordable Care Act didn't call it a tax. They called it a penalty. And President Obama and every politician near a microphone repeated over and over again, this is not a tax, this is not a tax, this is not a tax. Yet, the money paid goes to the IRS. It's on your tax return. It's subject to the usual rules of taxes, where if you don't make too much, you make too little, they vary it. Could the courts save it as a tax? Now, there's only one judge in the United States who actually concluded that this should be saved as a tax. His name is John Roberts, hence the broccoli version. But until this point, everyone said, of course, this is a regulation of commerce. Well, the law professor said, of course, this is commerce. The other argument involving the Medicaid expansion, no one paid attention to. Guilty, I didn't pay attention to it either. Because I had learned dutifully in law school, South Dakota v. Dole. And I studied O'Connor's dissent and Rehnquist's majority. And I said, well, this is related to a federal program. It's okay. Congress can put whatever strings it wants. And the first judge to rule that the Medicaid expansion was unconstitutional was, again, John Roberts. So I live by him, but I die by him. But let's get back to the case. Let's get to the story. The first round of litigation began in Virginia, and it was fired by Ken Cuccinelli, who was the Attorney General. And at the time, people laughed at this lawsuit and said, there's no way any judge will ever strike down the Affordable Care Act mandate, because this argument seemed so revolutionary. But indeed, Judge Hudson in Richmond, Virginia, found that the mandate was unconstitutional, that Congress lacked the power to make you buy insurance. And the president wasn't happy about this, because everyone said, there's no way the court strike this down. Indeed, one law professor at Yale compared this judge and another one to Roger Taney and Dred Scott. This was how harsh it was. But the ACA was not particularly popular at the time. Now it's 7 years later, it's creeped above 51%, just barely. But the big case was not the Virginia case, it was in Florida. 9 minutes after President Obama signed the ACA into law, Florida, at the time, I think 12 or 13 other states, brought a lawsuit challenging the ACA's mandate. Eventually, 26 states were part of that lawsuit. Count, 26. That's half the states in the union, not half the population. Red states tend to be smaller, but half the numerical states in the union were challenging this in federal court. Now, they brought suit in federal court in Tallahassee. I'm sorry, in Pensacola. I'm sorry, they brought it in Pensacola. The Florida Attorney General's office is in Tallahassee. Why did they bring the lawsuit in Pensacola and not Tallahassee?
The jurisdiction is more.
Forum shopping, of course. They had a more favorable bench. So again, all these Democrat attorneys general suing Trump in various favorable districts. They were suing in Florida and Texas and not New York and Brooklyn. Judge Vinson, though, ruled that not only was the individual mandate unconstitutional, but the entire ACA was unlawful. He said, you can't separate the mandate from the rest of the law. Because if you take out the mandate and you still have guaranteed issue for existing conditions, you get a death spiral. And the law was not designed to operate with a death spiral. So Vincent said, yeah, strike down the entire damn thing. And this was a revolutionary judgment, because at the time, I'm telling you guys, every law professor laughed at this idea. Or the same way they laugh at me now about emoluments. They laughed at the people back then about the individual mandate. Don't be laughing for long, because now you had two federal courts who ruled against the president's signature law. And it went to the federal courts of appeals. Now, you don't, as law students, you don't really study litigation going up the pipeline. You say, okay, Supreme Court, just look at one decision, but you got to get what happened in the lower courts. These cases are primarily argued by Neil Katyal, who was the Deputy Solicitor General under Obama, and this is Paul Clement, who was Bush's Solicitor General. Solicitor General is a person who argues before the highest courts. That's what we have. One note, Elena Kagan was the Solicitor General. He was deputy. Why was he arguing? Because Elena Kagan recused herself. She didn't participate in any Obamacare cases. Why? Because she knew she was about to be appointed to the Supreme Court and didn't want to have to step aside on the big case. There's a great email in my book, I have this, where Neil emails Elena and says, hey, you want to talk about this healthcare case? Know what her response was? What's your phone number? You know what that means, right? I don't want to put this in writing. And that was the last communication she ever had on the topic. So I don't think Kagan had to recuse. I'm somewhat alone in that. I think she recused herself. The better question is, why did she recuse? Ambition. Nothing counteracted it. In any event, one of the first cases to rule on it was in the U.S. Court of Appeals for the Sixth Circuit. I clerked there. I got there maybe a month after this case. I can actually talk about legit. I'm glad it was that separation. To the surprise of many people, Judge Jeff Sutton, who was a conservative, a Bush appointee, ruled that the Affordable Care Act must be upheld. So here we have one Court of Appeals ruling for the Obama administration. The next case, though, was the 11th Circuit Court of Appeals based in Atlanta. This had the Florida appeal. This case, though, did not come out so good for the government. Judge Frank Hull, Frank is a female, and Judge Joel Dubina wrote a joint opinion about the Affordable Care Act, and they ruled that the mandate was unconstitutional. And they argued this: Congress can regulate commerce, but when you're just sitting at home, uninsured, you're not in commerce. What the mandate does is it shoves you into commerce. And if the government has the power to shove you into the commerce, then they can regulate anything they want. Because once you're in the stream of commerce, remember that Asahi? You ever know where that came from? Stream of commerce? Oh, it clicks, right? Because once you're in the stream of commerce, they can do whatever they want to. They can't even put you in federal court. Oh, right, it clicks, right? It's all connected. But with that, the federal courts of appeals ruled that Obamacare was unconstitutional. Here we had a split, circuit split. Now, the circuit split, at that point, Obama had to go to the Supreme Court and ask for review. But there were two other courts of appeals I want to mention. The Fourth Circuit Court of Appeals, based in Richmond, Virginia, ruled in favor of the Obama administration. And most of the judges there did the easy thing, and they said, well, it's a regulation of commerce. But one of the judges ruled that it's actually a tax. Even though the president said it's not a tax on national TV and the law calls it a penalty, the court said we're going to treat it as a tax. But that was just a concurring opinion. And with that, the president was happy. It's a happy Obama picture, right? The sad one. But then we come to the final court, which is the D.C. Circuit Court of Appeals. And that court also upheld Obamacare, but there was one opinion by Judge Brett Kavanaugh, who worked in George Bush's White House, a very conservative judge, very good judge, who had this opinion. And he had this one section of his opinion that was very, very quaint. He said, if the law was a little bit different, right? If Congress had written this as a little bit differently, right? So instead of saying that it's a penalty for going uninsured, right? What if Congress just said, we'll tax you if you don't have insurance, right? Had Congress written that statute that said, we will tax you if you don't have insurance, that would be constitutional. There'd be no doubt about the constitutionality of that law. They didn't write that law. But Kavanaugh said, well, if you just read it, like, you twist it a little bit, you read a little bit differently, that could be a way to save the law. This message was not lost on the people in the Obama Justice Department. They paid a little bit extra attention to this victory for the president because they realized they had a silver bullet. Even if the court found that going uninsured was not economic activity, and even if the court found that this is not part of the necessary and proper power, for whatever reason, their plan B, their backup, was a taxing power. One of the lawyers, I spoke to a lot of the lawyers in the government, and I quote them in my book off the record, but one of the lawyers said something to the effect of, this was our quiver, right? We had this arrow in our quiver, we knew we could take it back. One of the lawyers confidently told me he knew Roberts would rule on this basis. Maybe he was lying, I don't know. But he told me this after the fact. But the government was very much concerned about the taxing power argument. We go to the Supreme Court, my friends. And the 9 justices, now Scalia's not with us anymore, but this was the 9 justices appointed, including 2 by President Obama. His first nominee was Sonia Sotomayor, and then a year later, Elena Kagan. Here, all the justices, this was in early 2009, or I guess it would have been late 2009, they all looked very happy. Actually, I'm sorry. By the way, if anyone goes to the Red Mass this year, Justice Alito is the speaker. This thing is on September 28th. I might have the date wrong, but it's a Thursday night at the Hilton. So if anyone wants to go see Justice Alito, go to Red Mass. I'm Jewish. I'm a Catholic, but I always go to it. I think it's a good show. But the Supreme Court looks very happy here, very cordial. They were not always so happy. So in January of 2010, President Obama gave his State of the Union address. This is one of the few places where the president and the justices interact. It's basically State of the Union and the inauguration. That's about it. And at the State of the Union, Justice Alito made a very big mistake. He forgot there were cameras. Now, at the Supreme Court, there are no cameras, so you can do whatever the hell you want. No one will ever know about it, right? Maybe someone won't write it down, but there's no picture of it. In fact, Justice Alito is very strict. He does not like to be recorded. I got in trouble. So once I posted on my blog a video a friend took of him, and I got this very nasty call from the Supreme Court saying, please take that video down immediately. So I actually got a prior exchange of speech from the Supreme Court. I complied. I should have, but I took it down. So during the 2010 State of the Union, which was issued, I think, about a week or two after the Supreme Court decided Citizens United versus FEC. This was a very contentious, controversial campaign finance case. And President Obama made a number of statements. He said that this case reverses 100 years of campaign finance law. It opens the floodgates of foreign funding. Those things weren't true. Now, we can say they're not true here, but Justice Alito did something worse. He was sitting there on camera and he was mouthing not true. It's a gift, but it works. After that, it made TV, and Justice Alito's not been back to the State of the Union since. Scalia never went, Thomas never went. We'll see if Gorsuch goes, I don't know, maybe he will, maybe he won't. I think he's a little smoother. But this shows early on that President Obama was not afraid to go after the court and to criticize the court publicly to their faces when they're 5 feet away. Moving on, the Supreme Court scheduled 6 hours of oral argument for this case. That was largely unprecedented in the modern era. It used to be days of argument time, but in the modern era, each case gets an hour, and barely that. So because there are no cameras in the court, the only way to witness it is to actually be there. And since tickets are not sold, the only way to actually be there is to wait online. Now, I didn't wait online for this case. I used to wait online for other cases. I once waited probably about 18 hours for a case involving the Second Amendment. Let me tell you guys, sitting on the street in Washington, D.C. for the night in March sucks because it's cold. It's very cold. And you can't bring a tent or anything of that nature. So you're basically sitting there. You can bring a folding chair, but that's about it. I'll give you another pro tip. The sprinklers come on around 3 in the morning, which makes for a very bad wake-up call. There are no bathrooms available in the court, so you have to walk maybe about a half a mile away to Union Station, which is basically a train station. You go to the bathroom there. There's some coffee shops open late at night. So it's a very unpleasant experience. And in recent years, it's gotten even worse because you have called paid line waiters, where they basically pay people to wait online, which may not sound bad, but these are generally homeless people that they give like $20 to spend a night in a line. They don't take care of it. It's actually it's unfortunate. But the worst part with the line waiters, what gets me angry, is they save multiple spots. So every day, there are about 50 tickets guaranteed available to the public. You get these actually little yellow golden tickets. They're cool. Right, so you get 50 tickets. I once was online. When I went to sleep, I was number 42. When I woke up from a nap, I was number 49 because a line waiter saved a couple extra spots. So I almost missed out after waiting all night. Not good. Now, I'm a member of the Supreme Court Bar. This is a special line for me. If any of you want to be a member of the Supreme Court Bar, 3 years after you pass Texas, you can apply. I will be happy to move for your admission. Might be my pleasure. I can't do it if you open in court because I'm not in D.C., but if you move to open court. Any event. So in this case, I think someone got there. I think she was from Atlanta. It was a mother with a child with disabilities. She got there 96 hours in advance and spent basically 4 days online. I think someone came to relieve her so she could go to a bathroom or something, but she was there for 4 days because this was important for her to see. And there's a picture of people sitting out there with umbrellas. And man, it was cold. It's a very cold thing to sit there all night. It's not fun. But there's no video. There is recording of the Supreme Court. There's audio, but it's only released later that day or sometimes later that week, so you don't get it in the live session. Oh, and by the way, I think it was raining that week. It was sleeting and snowing. It was a yucky day. And by the way, the Supreme Court police will not enforce the line. So if you go, hey, that guy cut me, they don't care. They're not going to do anything. It's become a huge problem for line waiters. It's a difficulty. Okay. In any event, the first day of argument, the very first day of argument, is something of a circus. People love protesting at the Supreme Court. It's like a thing. So the court itself, again, had 6 hours of arguments spread over 3 days. And the primary arguments were made between the Solicitor General, his name is Don Verrilli, and Paul Clement, who was a former Solicitor General. Now, I haven't mentioned much about the taxing power. I want to focus this a little bit more. All of you know April 15th, your taxes were due, right?
17th this year.
Oh, thank you, 17th. Hopefully all of you paid your taxes. Now, what happens if you had a problem with your tax bill? And you say the IRS sent you the wrong amount, right? They make you pay too much. Can you go to court and sue the IRS saying, I'm not going to pay my taxes now, and I'll pay them after this litigation finishes in 5 years? That's not how it works. There is a law called the Tax Anti-Injunction Act. The Tax Anti-Injunction Act. And what the Tax Anti-Injunction Act says is the federal courts cannot hear challenges to your tax bill until you paid your bill. In other words, you first pay your bill, and then you can sue for a refund and say, I paid too much. And the reason for this is obvious, right? If people could go to court to drag out their tax bills, no one would ever pay their tax bills, right? I think everyone agrees. You're lawyers, you're smart enough to realize this. So wait a minute then. If Obamacare was a tax, and the mandate imposed a tax, the tax didn't go into effect till 2014. No one would have to pay it till 2014. So how could anyone even challenge the tax back in 2012? So the first day of arguments, what the Supreme Court had to resolve was the Tax Anti-Injunction Act. If this was in fact a tax, and the tax wasn't enforced till 2014, how did the court have jurisdiction? So follow me here, folks. What the court said, so what the government said is, for purposes of the Tax Anti-Injunction Act, the mandate does not impose a tax. Let me say that again. For purposes of the Tax Anti-Injunction Act, it's not a tax. That is, the court has jurisdiction to hear it now. If they had waited 2 years, Mitt Romney could have been president, and we would have had a very different world, indeed. So the government said, for purposes of the Tax Anti-Injunction Act, it's not a tax. Right? For the statute, this Tax Anti-Injunction Act, it's not a tax. However, for purposes of the Constitution, it is a tax. What? The same exaction, the same payment for the Anti-Injunction Act, not a tax. For the constitutional argument, it is a tax. This was the government's argument. As sick as John Roberts makes me, he wasn't that creative. He got it from the government, right? He didn't make it up himself. He got it from the government. And this was the basis of the argument advanced at the very first day. No one paid attention to the first day. The second day was a Commerce Clause. People paid attention to that. But the first day was all about the Anti-Injunction Act. And this is where the government made their case. They said, look, we are not going to treat this as a tax for the statute. But for the Constitution, the court has a duty to read it as a tax if they can. And that's what they did. Okay? But there's a problem with calling this a tax, right? If there's a mandate and people are required to pay this mandate, they don't pay it. Are they lawbreakers? Right? If someone's a criminal, that's not, that's a big deal to say that failure to pay a tax is making you a criminal. So what the government said is this: if you don't pay the tax, you're not a criminal. You're not breaking any law. The only consequence is you have to pay interest on the tax bill. And the government can't even go after your earnings and take it away from you. So what they argue is, this is really a tax, even though it's not called a tax. That argument went surprisingly well. And Chief Justice Roberts, if you listen to his comments, was very sympathetic to that position. By the way, this is a terrible drawing of Justice Kagan. I don't know what the hell they were smoking when they do that. That's a really bad picture of her. Her head looks like a little thing. It's bad. That was day number one. Day number two did not start out well for the Solicitor General. And this is an advocacy tip to all of you who all join the advocacy team at some point in your career. Do not drink water immediately before you make an argument, because it may go down the wrong pipe. So can you imagine the Solicitor General of the United States making the most important argument of his entire career, right? Gets up there. Mr. Chief Justice, may it please the court. He says a few more words. And then there's silence. Complete silence. He started choking. Literally, the water went down his wrong pipe. He couldn't breathe. And if you listen carefully to the recording, you can hear him reaching for a glass of water and like clinking it around and taking a sip. But, and I'm giving Don Verrilli a lot of credit here, after he choked, literally, not like figure, he literally choked, he resumed his speech from the beginning verbatim. That's skill. He had his opening committed to memory. And even after he choked, he went back to the beginning of the sentence and said it verbatim. That's impressive. I can't do that. If you guys as lawyers can do that, kudos, right? But the guy has skill. That is remarkable to even screw up that badly and recover. Anyway, it went downhill from there. That was basically the highlight of his day. Because the government recognized that it couldn't answer one very important question. What is your limiting principle? If Congress can make you buy insurance, what can't they do? What are they not able to do? Because once they make you buy a commercial product and you're in that stream of commerce, they can regulate you to the hill. They can do whatever they want. This was an argument that the government knew they probably weren't going to win. Because they recognized they don't have a limiting principle. Even if you look at Justice Breyer's dissent in Lopez and Justice Breyer's dissent in Morrison, they don't have one. They say, well, they push back on that conclusion. Now, the government's best argument was this. This is not about activity versus inactivity. Why? Follow me here. Going uninsured is a form of insurance. What? Self-insurance, exactly, thank you. What the government argued is that when you go uninsured, you are actually self-insuring. And that is an economic decision which Congress can regulate. I mean, it's a decent argument, and it could have gotten 5 votes, but it didn't. The government's backup argument was not just commerce, but also necessary and proper. It said, look, even if this is not an economic activity, it's part of this broader regulatory scheme involving the guaranteed issue, the pre-existing conditions, right? And in order to have pre-existing conditions, we need the mandate. But here comes McCulloch v. Maryland, right? We keep dancing around this case, coming back to it over and over again. Chief Justice Marshall, 200 years ago, said that the necessary and proper power is incidental. It's secondary. It doesn't let you exercise great and substantive independent powers. Was making people buy insurance a bridge too far? Right? Was making people buy insurance inconsistent with the spirit of the Constitution? Remember that? The spirit of the Constitution? And I said, I don't know what the hell it means. Ask me in a week or so. Like, now, 2 weeks, right? This is it, right? The court asked him, is it consistent with the structure of our Constitution to use necessary and proper to make people buy health insurance? That was this novel argument by the challengers, that this was not a proper exercise of federal power. Only twice before the court ever struck down law as not being proper. You haven't read those cases yet. You read them, I think, next week. One of them called New York versus United States. The second one, Printz, P-R-I-N-T-Z versus United States. Okay? So that was day 2 and really did not fare very well. Paul Clement did quite well with those arguments. Okay? Day number 3 involved the Medicaid expansion. And this was the sleeper issue. When I say the sleeper issue, no one paid much attention. No one paid much attention to the Medicaid expansion. And let me summarize it again. Before Medicaid expansion, states had a lot of flexibility of who they covered and what sort of benefits they provided. The Affordable Care Act said, no, you have to cover everyone at 133% of the poverty line. And, here comes a big N, if you don't, there's a punishment for that. Way back in the early days of the litigation, the state of Arizona sent a letter to the government letters available, that said, what happens if we don't expand Medicaid? And some low-level functionary wrote back and said, if you don't expand Medicaid, you will lose your entire budget of Medicaid. I think it was about $10 billion a year. I think it was almost 15% of Arizona's budget. So the states argued this. They said, wait a minute, we don't have a choice. Persuasion has crossed the line to compulsion, and we no longer have a valid choice. Now, again, no court had ever struck down anything under the spending clause. The closest happened was in South Dakota v. Dole. That was 8-1, right? And only O'Connor struck down the highway funding for the drinking age. But there was this one exchange during the arguments at day number 3 that stuck out. And the Chief Justice asked, really, what's the consequence of not expanding? And really tried to tap dance. And Roberts goes, what about that Arizona letter? And the second he asked about the Arizona letter, really knew what was going to hit him. It's like a ton of bricks, because that Arizona letter should never have been sent, but they sent it. It was in the record. And Verley said, well, blah, blah, blah. He knew he was toast. And they used this image, right? There's this old, it was an old TV comedy sketch where a robber walks up to a guy, puts a gun to his head, right? He says, your money or your life? And the guy's sitting there thinking, waiting. And the robber goes, what do you mean you're waiting? Your money or your life? And he goes, I'm thinking about it, right? And the reason why it's funny is who in their right mind would think about it? The guy's going to kill you, give away your money. So what Roberts and others were suggesting in arguments is that the states had no meaningful choice. And then when the states have no choice, it violates the spending clause, it becomes coercive. Now remember that 4-factor test from South Dakota v. Dole? Did Roberts even mention that? Nope. Nope, didn't even mention it. Instead, he cited the Stewart Machine Company case from the 1930s, which people thought was overturned, but it wasn't. And in that case, they said there's some point where the conditions become coercive, that's too much. Now, what the government argued is that there's no difference between this new Medicaid and old Medicaid. Each new iteration is a new funding requirement, right? And you have to play along with the conditions. And if the federal government wants that their programs to work a certain way, they can put these terms. But if you listen to those arguments, they did not go well for the government, and the government knew it. Because usually, with the South Dakota v. Dole case, they lost like a few $1 million in highway funds, trivial. But here, we're talking like 20% of the state's budget. I ran the numbers, they were huge numbers. The final argument was actually on a Thursday afternoon. I'm sorry, on Thursday afternoon, concerned something called severability. Severability. This is not in your book, but I'll talk about it for a minute. Severability. If the individual mandate is unconstitutional, what happens to the rest of the law? Now, the government actually changed their position. They said that if you strike down the mandate, the entire law has to go. Because Obamacare cannot operate without a mandate. By the way, the mandate's been suspended for millions of Americans. It hasn't actually been enforced. So that wasn't quite accurate, I suppose. But they said, we will not allow the law to survive. So the court had a choice, right? They couldn't take the easy way out and strike down the mandate and leave everything else. So they had to basically say, we're either killing it all or killing it none. It chose the latter. Justice Scalia asked a broccoli question, and also asked a question about buying cars. Okay. So that's the argument. After the arguments concluded, everyone thought that the deciding vote would be, of course, Justice Kennedy, who is always the swing vote in every case, who decides who lives, who dies, who gets married, who doesn't, who keeps their home, who doesn't, right? He is, I'm only slightly exaggerating, he decides all that stuff for us, Forget Congress, he's our overlord. But indeed, for once, the swing vote became Mr. Broccoli, Chief Justice Roberts. Like a doe into the headlights with this picture. Over the weeks after the Obamacare case was argued, there was a strange vibe that came over D.C. And there were leaks from the Supreme Court. Now, usually the Supreme Court is the only branch of government that doesn't have leaks, right? But there were leaks from the Supreme Court. And I can only tell you what was in my book. Maybe people heard of other things. But there was the sense that people on the outside knew that something was up. And from my own reporting, for whatever it's worth, which is not much, they give you the book for free, the initial conference vote was that the Chief Justice said that he was willing to strike down the law on Commerce Clause and Necessary and Proper Clause grounds. What I don't know for sure was what his position was on the taxing power. I've heard different things, that maybe he was on the fence, maybe he was wobbly. We'll leave it there. But at some point, the chief decided for certain that he would vote to uphold the mandate under the taxing power. During this time, though, there was this weird sentiment going on outside the court where a number of politicians made statements saying that, John Roberts needs to be the Chief Justice for all of us. And all these politicians were talking about Roberts. They weren't talking about Kennedy, they were talking about Roberts. Were they being motivated by rumors? I don't know. Maybe. Probably. I don't know. Read my book. But there was definitely what Randy Barnett called a campaign of disdain. And the argument went like this. If John Roberts votes to strike down the Affordable Care Act, there will be blowback against the court. The same way that FDR attacked the court in 1936, Barack Obama would attack in 2012. Mind you, there was a presidential election 5 months away. So we were right on the cusp of a presidential election. Whether those efforts worked, Randy Barnett thinks they did. I reserve opinion on that. I have no idea. But then, after the liberal attacks, came the conservative attacks. And in early June, there were all these articles from conservatives saying, John Roberts, grow a backbone, right? Grow a spine, John Roberts. Don't wobble. What did they know? I don't know. I was a lowly law clerk at the time, so it's sitting on the outside like Rosencrantz and Guildenstern. I was kind of on the outside, didn't really know what I was doing. Mostly exaggerating. But eventually, the chief made up his mind. And the opinion you read is a strange one, right? Who's in the majority? Who's in the dissent? You probably have no idea, do you, right? So let me break it down for you. There are 9 justices. To have a majority opinion, you need 5. But you don't always have 5 at any given point in time. So let's break this down like this. For the position that the mandate is unconstitutional to the Commerce Clause, there were 5 votes, right? You had Roberts, Scalia, Kennedy, Alito, Thomas. But if you notice, the 4 didn't join Roberts. They did not. They wrote their own separate opinion. This gave rise to some rumors that there was hope that Roberts would change the opinion at the last moment. They could persuade him to join at the last minute. That's bogus. That's not true. I think they were pissed off at Roberts that anyone joined his opinion. They were angry. There was a lot of anger that emanated from the court that year, a lot of animosity. So you had 5 votes to say that this is not sustainable under the Commerce Power. The same 5 votes said that the mandate was not sustainable under the Necessary and Proper Clause power. But then we went to the taxing power. This is where John Roberts' saving construction comes in. There were 5 votes to uphold his attacks. You had Roberts, Ginsburg, Breyer, Sotomayor, Kagan. So, look at this, right? Like Sesame Street. You have 5 votes to strike down the mandate, and you also have 5 votes to uphold the mandate. What is the consequence of that? The mandate survives. But that wasn't the end of the opinion. You also had the expansion of Medicaid. Only 2 justices, Sotomayor and Ginsburg, would have upheld the Medicaid expansion in its entirety. 7 justices agreed that was unconstitutional. You had the 5 conservatives plus Kagan and Breyer. But Roberts, Kagan, and Breyer had an additional portion, which was run by 3 people. And that 3-person opinion says this, that yes, the expansion is coercive, but states have a choice. If they want to keep the money, they can. If they don't want it, they don't have to take it. So even though 7 justices found that the Medicaid expansion was unconstitutional, because 3 of them agreed to this remedy, the Medicaid expansion survives in large part. I mean, to this day, about 20 states still haven't accepted the money, which has created this weird anomaly where states should have it that don't, right? Let's say that, like, you're at the poverty line. You're not eligible for Obamacare subsidies, but you don't get Medicaid in Texas. You get no insurance. So this created a weird anomaly, a very weird anomaly, when the court rewrote the law. So everyone get the vote breakdown, right? So again, you have 5 votes to strike it down in commerce. You have 5 votes to strike it down in necessary and proper. You have 5 votes to uphold it as a tax. You have 7 votes that the expansion is unconstitutional. But you have 3 votes to say we have to save it by rewriting it. Crazy, huh? Now there's a study guide question in your book, which says, can you imagine why the newspaper reporters blew the call? This was CNN's headline for a good 15 or 20 minutes on decision day. You see, what happened was the reporters from CNN. By the way, the Supreme Court's. I'll tell you the full story. The Supreme Court's website crashed entirely that day. You couldn't get the PDF. So the only way to actually get the opinion was by having an intern run. It's called the running of the interns, right? They actually have interns with suits and dresses with sneakers sitting in the Supreme Court. And literally, there's a person with a box of opinions, and they hand them out one at a time. That's how the Supreme Court operates. So you get one of these kids, right, probably not much younger than you, 19, 20 years old, right, taking the opinion, running out to the street, and it's a pretty long walk, it's about a quarter mile, right, with all the stairs and stuff, and handing it to a reporter. And you can see the reporter on the street reading the slip copy of the opinion and reading the page. I can watch the video, I'll show it to you, where Robert says this is not a valid regulation of commerce. And they stopped there. They didn't read on to the next part where I started vomiting, where the court upholds it as a tax. I get my broccoli sensation. And they said to the producers, mandate struck down. So they had these headlines written already. They basically had 2 headlines, mandate upheld, mandate struck down. So for a good 15 minutes, CNN was running the headline that the mandate was struck down. Guess who was watching CNN? Obama. Yeah, so for a good 15 minutes, the website of the Supreme Court was down. Obama thought his law was gone. Megyn Kelly, who was then at Fox News, had a similar report, although she was looking at her iPads like, you guys, I don't think this is right. Like she was looking at SCOTUS Plus, like, I think this is wrong. Now, my own personal story is actually a good one. So I was supposed to fly to London that day, and I knew that was going to be the last day of the term, so I deliberately scheduled my flight such that it would take off around 10:30 Eastern time. The Supreme Court session begins at 10 o'clock Eastern, right, 10 o'clock Eastern. So I said, okay, good. It'll give me at least 30 minutes to download the opinion, and I can read it on the 6-hour flight from Chicago to London, and I'll be good to go. There wasn't Wi-Fi on flights back then, but I'll download it beforehand. So I'm sitting there on the plane, and if anyone's ever flown out of O'Hare Airport, right? Have you ever flight on time at O'Hare? Like an international flight on time at O'Hare. We boarded early. I'm like, uh-oh. So I was boarded by 10. I was like, this is not good. So then, I'm looking at my phone and I'm messaging with my girlfriend. I was like, okay, as soon as the opinion comes out, email it to me. She's like, okay, I'll do that for you. So there were a couple opinions, small ones I didn't really care about. And then at like 10 after 10, we start taxing. I'm like, oh crap. And I'm like, to my girlfriend, what happened? What happened? She's like, CNN said they struck it down. I'm like, oh my God, they struck it down. And like, I'm like freaking out. And then like, send me the opinion. She's like, I can't, the website's busted. I'm like, send it to me. And she couldn't get it. And then, I swear, we were about to take off. We were zipping down the runway. I have the message, my G-chat. And as we were going off, it says, John Roberts voted to uphold the mandate. And then I had 7 hours of silence. I had that message, and I think I matched right, like, what? And that was it. And there was no Wi-Fi. So I had 7 hours from Chicago to London Heathrow of silence.
So sorry.
It was cathartic, actually, because I actually read the other opinion, which was a little bit interesting, about the Alvarez case about free speech. But I had this weird thing. I was like, what the hell just happened? And then, but I was like in this cocoon, right? Because as the world below me was blowing up and people were going absolutely insane, I was cool. I was on a plane. The only bad part was there were no outlets back then, and my computer had power. I didn't know what the hell to do. So I finally land. It's like, midnight or 1 a.m. local time. I turn on my phone. I had like 200 messages. And the reason why this is funny is I was pitching my book at this time. And I had given my agent 2 different proposals. And I said, look, here's one proposal where the law is struck down. Here's a different proposal where it's upheld. You just send over which one is applicable, right? Because I wanted to get like people reading it the day. And I'd send this friend, and I was like, don't send anything, I'm all wrong. I actually wrote 2 different endings for my book. The book was basically done at this point. I wrote 2 different chapters to end it. Because I thought, tweak Kennedy this way, Kennedy that way. I was all wrong. So, in hindsight, it was very cathartic. And then I think I stayed up all night in London in this little hotel room. Everything in Europe is smaller. I love Texas, but it's true. I don't fit in Europe. The showers, everything's tiny. But I stayed up all night reading the opinion, and I didn't know what the hell to do. It was stunning, right? But the bottom line, as I walk you through the opinion, is that the Chief Justice, for reasons unknown to me at least, 7 years later, I swear every time I read this decision, I keep hoping it turns out differently. It hasn't happened yet, but I always have the same sentiment as being in that London hotel room going, oh man, maybe this time will be different. It hasn't happened yet. By the way, this is a case where I don't pretend to be objective on. I have no pretense. They usually can be, not this case, too involved. So let me walk you through the Chief Justice's opinion. I'll do the best that I can. The crux of Roberts' opinion was the Tax Anti-Injunction Act, something that no one cared about. And what the court said, and what Chief Justice Roberts said, is this is not a valid regulation of commerce, number one, right? It's not a valid regulation of commerce. This is making people enter the stream of commerce. It's not an economic activity. And if you look at Lopez, Raich, and Morrison, they're all about economic activity. Going uninsured is not an economic activity. He rejects the self-insurance argument. Number two, they go into necessary and proper, right? He said, it's true, there is a broad regulatory scheme to ensure you have guaranteed issue and pre-existing conditions. You have this broad scheme. But this is a great and substantive independent power. To make people buy insurance transcends this marketplace and does something that's never been done before, mandating the purchase of insurance. That is a bridge too far. So the law might be necessary. That is, it's convenient to having this guaranteed issue scheme, but it is not proper. If you want to understand necessary and proper, read Roberts' opinion. It's even better than Scalia's and Raich. The outcome, whatever, but the actual analysis of necessary and proper, he nails it. He gets it perfectly. Which is why he has such precision with the Commerce Clause, necessary and proper clause. Then we'll get to the taxing power, which I think just goes out the window. It doesn't matter anymore. So as a threshold matter, if a law can be upheld under the taxing power, why did you have to waste 20 pages reading about commerce and necessary and proper? So Roberts has an answer here. He says, I only turn to the taxing power because the other ones are unconstitutional, right? He doesn't actually say that the mandate is a tax. Now, I'll make this point very clear. What he says is, as a judge, I have a duty to read it as a constitutional way. I have a duty to treat it as a tax. So if I were to ask a true-false question, is the mandate a tax? The answer is no. Only for the purposes of the saving construction. The saving construction is the mandate a tax. In fact, he says, if ever in the future the mandate becomes too high, right, and the penalty is too great, maybe it's not a tax anymore. If they start throwing people in jail for not paying their health care bill, right, that may not be a tax anymore. So there's a limit on the taxing power argument, but he's willing to save it as a tax. And all this stems from the Solicitor General's representation, which he cites the transcript, that there's no criminal consequences for going uninsured. It's purely a tax. Now, perhaps the most frustrating portion of the NFIB case, there's a lot of frustrating portions, but perhaps the most frustrating portion is usually when you get Kennedy, you win, right? If you persuade Justice Kennedy, that's usually enough for the conservatives at least. Kennedy was willing to vote to strike down the entire law. And the opinion, which is signed by all of them, by Scalia, Kennedy, Alito, and Thomas, they all signed it together, it was not authored by any one of them, explains in gruesome detail why the majority is wrong. Now, they agree with Roberts on the commerce and necessary and proper clause, but they don't join his opinion. I think that was just bitter pettiness. But they're on the same page there. In fact, I think Roberts' opinion is a little bit better on necessary and proper than Scalia's, but I'll leave it there. On, however, the taxing power, they disagree. The joint dissenters, and here are the joint dissenters. They don't actually dissent everywhere, but with respect to the taxing power, there are joint dissenters. The joint dissenters argue that Roberts rewrote the statute, that Congress framed it as a penalty. The politicians insisted, hey, everyone, can I have a seat, please? This is my friend Seth Barrett-Tillman. He's a law professor in Ireland.
My title's lecturer. There are very few professors in Europe.
Well, he
20 more years.
He is one of the foremost experts on the Foreign Emolument Clause in the world.
That's not saying much, folks. Really.
And Seth is speaking at the South Texas Law Review Symposium tomorrow on the Foreign Emoluments Clause. So if you're free, come on by to the 6th floor library. But Seth will be with us. Seth, we're talking about Obamacare today, NFIB versus Sebelius.
That's an important case.
And we're on to the joint dissent of Scalia, Kennedy, Thomas, and Alito. And they charged the Chief Justice with rewriting the statute. They asserted that it was called a penalty. The president called it a penalty. All the politicians called it a penalty. I mean, now it's, of course, vogue to quote the president's tweets. Back then, we didn't do that, right? But it didn't matter what the president said, because the court has an obligation to save the statute and defer to Congress. So the dissent said, you are rewriting the statute. Now, the dissent made another charge against Roberts, right? He said that with the Medicaid expansion, you can rewrite it. States that want the money can take it. States that don't want the money don't have to take it. But you keep it in effect. The joint dissenter said that's nonsense, right? If the statute's unconstitutional, strike it down. Don't create this weird judge-made regime where some states have it, some states don't. And I'll give you a very easy example. Texarkana, right? Texarkana sits right on the border between Texas and Arkansas. If you are on the Arkansas side and you have a poverty line salary, you get Medicaid, you get government insurance. If you cross the street and you go to the Texas side, you're out of luck. And not only are you out of luck, because your salary is at this weird sweet spot, you don't get any subsidies on your health insurance. So basically, it's unaffordable. The Supreme Court created this weird chimera, this weird like mutant Obamacare that was never designed to exist by allowing the Medicaid expansion to exist in its present form. And to this day, some 20 states have not accepted the Medicaid money. They probably all will. Justice Thomas's dissenting opinion reiterates his points from Lopez and Morrison. Basically, the New Deal was wrong. And Thomas would go back and revisit the substantial effects test. He says the Commerce Clause says nothing about substantial effects. This is a judicial-made construct. But he joined the joint dissent. The votes of Justices Breyer and Justices Kagan are perhaps the hardest to explain the entire case. They agreed that the mandate should be held up in its entirety, but they joined the Chief Justice's opinion concerning the Medicaid expansion. And they all seemed to agree that this was too coercive, that this Arizona letter went too far. But the speculation, and what do we know, right? But the speculation is that the reason why they joined the Roberts opinion was to moderate it. That perhaps Roberts was prepared to strike down the Medicaid expansion in its entirety. And by giving some liberal votes to Roberts' position, he agreed to moderate. Maybe yes, maybe no. We won't know until the paper's released, which might not be until after all of your deaths. The justices tend to be very strict about that, some more than others. Justice Souter said his papers will not be released until 50 years after his death. I think that's right. 50 years after his death. He's like in his 70s now. So it might not be for another like 60 or 70 years. I made a pact with someone when 100 years old to go read Souter's papers, but it might be a while. And then we have the opinions of Justices Ginsburg and Sotomayor. They would have upheld the Affordable Care Act in its entirety. And they make a number of accusations against Roberts. So first off, they say, you're not being consistent with Raich, right? Justice Stevens defined economic activity very broadly in Raich with Webster's Third Dictionary. Remember that? Under the definition of Raich, I think probably self-insurance is an economic activity, probably. But they say, look, you're abandoning Raich, and you're going back to the pre-New Deal. You're going back to before Darby, Jones and Laughlin Steele, right? You're going back to E.C. Knight and these other cases. And she also attacks some of the cases you haven't studied yet, but you will study soon, a case called Lochner versus New York. And the actual facts of this case aren't that bad in the grand scheme of things. It involved a law restricting the number of hours that bakers could work per week. But this case has come to represent judicial conservative activism, right? That conservative judges are stopping progressive legislation. It's become this huge bugaboo. We'll study Lochner later. And one of the worst insults you can give to anyone is say you're a Lochner, right? You believe in Lochner. If you come to my office, I have a print of Lochner's bakery on my wall, but you'll see that perhaps later in the semester. But they said this is not the modern regime. You are going before the New Deal, and this is an exercise of judicial activism. This is Lochnerism. This is wrong. Ginsburg says, but in the grand scheme of things, Roberts voted to uphold the law in almost entirety, so the net effect of this is little. Does Obamacare, does NFIB versus Sebelius change our doctrine? Right? Does this affect anything else? I don't know. I keep going back and forth on this. Maybe it does, maybe it doesn't. For sure, Congress can impose a purchase mandate, but what other limitations perhaps are void? The spending power one I do think has some teeth, but I go back and forth by the Commerce Clause. It's already mentioned before that the various news networks screwed up. They reported incorrectly, and poor President Obama was watching CNN, and eventually one of his aides rushed into the room, and with Happy Obama, and he told him that the law was upheld. And he was like, wait a minute, I saw it on CNN. I guess fake news, right? As it were, it was a Dewey defeats Truman moment for the digital age. Solicitor General Verrilli argued the case well, and I think he helped win the case. But ultimately, it was the Chief Justice who did a little surgery on the law. Now, the reaction to this decision was not what people expected, right? Had Roberts voted to strike it down, he would have been attacked by the left. But instead, he was attacked by the right. In fact, these are people who had supported Bush and supported the nomination of Roberts a couple years earlier. And people like Glenn Beck and others called him a coward. And I think to articulate this, they felt cheated, right? Because they had the victory, right? They had the same text message I did, that Roberts voted to strike it down, and it was yanked away from them. And I don't think you can undervalue that. It's like, you know, you have something good and then they take it away from you. That's worse than never having it in the first place. It's called the endowment effect, right? You value what you have more than if you never had it in the first place. Mitt Romney, in any event, campaigned to repeal and replace Obamacare. This promise was never going to happen. 7 years later, it's still not going to happen. The reason why is that as governor of Massachusetts, Romney basically invented Obamacare. He invented Romney Care, which was designed to have a mandate and subsidies that worked in a very similar fashion. During one of the 2012 presidential debates, Obama called Romney the godfather of Obamacare. The godfather. He was right. He was right. So I largely expected after the 2012 midterm elections that the repeal effort would fall apart. I was wrong. The fight to repeal Obamacare continued in the 2012 election, the 2014 election, and the 2016 election. Whether Congress will muster the votes to repeal the mandate, I don't know. Ironically enough, even though the mandate is unpopular, a general sentiment has emerged that it's a necessary component of the healthcare law, so I doubt that the Congress will kill what the Supreme Court didn't. Some months later, in January 2013, President Obama took the oath of office from Chief Justice Roberts. I would love to have heard what they were talking about. They're like, thanks a lot. Because had the chief voted differently to strike down the law, I think the election may have turned out differently, and our republic as well. So here we are, the constitutional debate, this challenge between Obama and Roberts. Obama's out of office now. Roberts is still there, and he'll be there for some time. And the same sort of institutional dynamics of how the court stood up to Obama and maybe backed down, I think we'll see very soon how they handled Trump, in very much the same way. So I'm going to stop there, and I'll take some questions. I might lecture a bit after that, but let me stop and pause. Thank you all very much. Questions? Yeah, Brad?
Can you explain Scalia's direct tax argument?
Oh, thank you for asking that, yeah. So, the Constitution specifies that there are only certain types of taxes, right? So the tax you're probably most familiar with is an income tax, right? You pay your tax to the IRS every year. That came much later by amendment. Under the original tax, you have what are called direct taxes, right? And you have excise taxes, like taxes on like whiskey or stuff like this, right? Taxes have to fit into either of those buckets. If it's a direct tax, it has to be apportioned by population. What that means is you base the population of the state and then you divvy up the amount each person pays. An excise tax, like a tax on whiskey or something like that, is per item. Where does Obamacare fit in that? Is it a tax on an item? Well, you're not really buying anything. It's not apportioned. So what Scalia argued is that this tax was a unicorn, right? It's never been seen before. The government spent like 3 sentences in their briefs arguing about this. They basically didn't care about it. John Roberts made up a lot of stuff, right? He basically said, well, the government says this, and we're going to ignore the rest of it. So the court doesn't actually address what kind of tax it is. They just ignore the issue altogether. That exact reason is why the Roberts opinion is complete BS, right? I can live with the saving construction. It took me a couple of years, but I've actually come around to the saving construction. It's not insane. But the direct tax argument is the problem. Because by avoiding the Commerce Clause, he ran right into the direct tax issue. And this is a question that's plagued the Republic since the early days of the 1800s, right? So Roberts avoided one constitutional problem and created another bigger one, right? You don't avoid a problem by creating another problem. That's not how avoidance works. So even though I'm okay with the saving construction, the direct tax argument doesn't work. One other point worth mentioning, under our Constitution, taxes must originate in the House of Representatives, closer to the people. Where did Obamacare originate? Trick question. So yes, the Affordable Care Act bill began in the Senate, but there was a wrinkle there. People in the House recognized they were going to have this problem. So what did they do? They took a bill that passed the House, involved tax credits for service members. Passed the House. They brought it over to the Senate and they gutted it. So imagine you take a bill about tax credits for service members, you empty it out, and you put Obamacare into it. So in fact, Obamacare began in the House. It was called a shell bill, right? Like a shell game, like 3-card money, right? It was a shell bill. It was a scam. So a number of groups after the NFIB case challenged the Obamacare tax, saying it didn't originate in the House. And the courts ruled against them, saying that because the shell bill is permissible. There's a lot of fast and loose constitutional law with this case, but that's just another illustration. Other questions? Come on.
Are there
Yes.
other examples of, so like how the Medicaid expansion was changed by the justices? Are there other examples of that happening?
Rewriting statutes?
Yeah, like creating.
Seth, think of any? That one's pretty egregious. Yeah, I'll think about it. I mean, that one's pretty egregious. I mean, usually the way it comes up is this, right? If there are 2 reasonable constructions of a statute, right? One constitutional and one unconstitutional. Courts prefer to the constitutional construction, right? So if you have an ambiguous statute, read it one way or the other. You prefer the one that results in the law surviving. But they didn't do that, right? They said, we realize the statute doesn't say that, but we'll pretend it does. So I'm not aware of, maybe Seth could think of, but I don't know other cases that get you there, but it's a, this opinion was not supported by general canons of jurisprudence. Yeah.
So, I mean, I was on the front lines with this. I own an S-Corp, and so I was an independent contractor for a number of years before I came back to law school, and so, like, I was directly impacted by this ruling, and I had a couple of interesting run-ins with it. Like, you know, the first year, I think the option for me to get by from the marketplace for any sort of reasonable coverage, I think was like $500 a month or something like that, which is basically COBRA levels, which I would have had all along. And then if I would have just not done that, I would have just paid the fine that would have resulted into somewhere around $5,000, which I think is ultimately what I elected to do.
You took the man.
I paid the bill, right? Because I was like low six figures.
I have a lot of students who did that.
So then the next year, how did it work? So I needed to give a prediction of how much I was going to earn,
right?
And that was, you know, determining how much, you know, my coverage was going to cost me. And then at the end of the year, after I had paid my taxes, they came back to me and said that your earnings exceeded your expectation, and so now you owe us the spread of what you paid and what you didn't pay. And ultimately, I never paid that bill. So, and they've never come back to me on it either. So,
You may not want to admit that.
but I guess that, I don't know if they can really like.
Well, actually, so
Right.
here's the issue, right? One at a time, guys, one at a time. Here's the issue. The Obamacare, the law itself says they can't collect the mandate.
Exactly.
All they can do is withhold it from your refund.
Right.
And if you jigger your taxes or you don't get a refund, you never have to pay it. I am not giving you advice on tax evasion. I'm giving you advice on tax avoidance. There's a very big legal difference.
But I tried to play ball.
Not in England.
Not really.
Not in England. In England, the traditional breakdown between tax avoidance and tax evasion is broken down, and the judges looked at that again and said, merely illegally avoiding your tax bill, if it is morally culpable, might not be.
That's why we threw the tea in the harbor. So yeah, your question?
Oh, I was like to say, so essentially, because there's no way for them to really collect it, and they can't really throw you in jail.
That actually supports the chief's holding of that's actually a tax, not a penalty, right?
Yeah.
If it was a penalty, right? If it was a penalty from the Commerce Clause, and you fail to pay a penalty, the result is you go to jail. So that actually supports the chief's opinion about the taxing power.
So essentially, like you said, I mean, if you do, you don't ever actually really have to pay it because there's really no consequence.
If you're savvy enough with your taxes, you can get away from it. But as long as they can take out your refund, but if you never have a refund, they can't take it away. So if you always owe money, they'll never pay it. Yeah, I mean, one thing the ACA people don't. Yeah. One thing that people don't realize about the ACA is that it's basically a tax on young, healthy people. I know millennials love the law, but basically it's an awful deal for them. It'll be great when they're 30s and 40s, right? But it's basically a tax on young, healthy people to subsidize old, sick people. That it's redistribution. There's no other way of describing it.
It was a great deal for people that didn't work, you know, that were able to take, you know, Medicaid, right? But for the working man like me that had to get crap coverage at COBRA prices, you know, it was awful. And I don't mind paying a tax on like an Italian suit that's imported, you know, because I feel like it's a better suit than what I can get domestically. I choose to pay that tax, but like the tax that they provided, that they made us pay on shitty insurance coverage.
Oh, okay. Keep it kosher.
Was not, you know, it didn't fall in line with, you know,
PG.
a choice, you know, to pay a tax. So.
All right. Other questions in the actual case? Yeah.
So in regards to what Trump is trying to do now with, I'm not sure, I'm not following him with that, but with Trump Care, and that's what they're calling it now, do you see that actually going through, or making it to the Supreme Court eventually?
So I'll give a preview of my third book. The first book was called Unprecedented, The Constitutional Challenge to Obamacare. The second book was called Unraveled, Obamacare, Religious Liberty, and Executive Power. The third book I think will be called Undone, to keep the nomenclature. I don't know what is going to pass. No one actually knows for sure. One deadline, though, that is important is September 30th. The method by which the bill was enacted, I mentioned this budget reconciliation process, allowed the bill to go through with only 51 votes. What's passed with 51 votes can be repealed with 51 votes. So there's a deadline, though, to actually use that process. Expires expires at the end of this month. So if a bill can actually pass the Senate by the end of this month, we actually may get some legislation. I'm not optimistic. My opinion, I believe this firmly, is passing these momentous bills with a straight party line vote is an awful idea. Because if people don't agree with it in the outset, they're going to fight it kicking and screaming, going to court and everything else. So, yes. Yeah.
So when you're talking about people that actually voted for it, what binding authority really comes out of this case because of the split?
It's a good question.
Because, I mean, is it really a majority opinion or a plurality?
It's a very good question, right? Because the 4 votes for the majority, the 4 votes for the Commerce Clause and that's improper, they didn't join Roberts, right? So in theory, you have 4 and 1, which are the exact same thing. My reading of it is that there are 5 votes for this position, but if you don't believe me, John Roberts used the Blue Book signal, right? I can't remember which signal it was, but he basically said, I agree with the other 4 guys. So Roberts signaled by Blue Book signal that he agrees with the 4, I think that's the accomplished the other 5. But the better question is, even assuming there's 5 votes, what's it good for, right? You can't have a purchase mandate, for sure. But does this change rates? Not really. Does this overrule Lopez? Does it change anything? So I don't think this changes the status quo very much. I think it more or less keeps constitutional law where it was with the addition of this purchase mandate. Other questions? Yeah, Carla. Yeah.
I don't understand how the 3 votes on the expansion,
Yeah, good question.
only 3,
Good question.
allowed them to change.
Yeah, so there's a rule on the Supreme Court that when you have a division of authorities, the most narrow rule controls, right? So even though you had 7 justices who agreed on the expansion being unconstitutional, there was no 5-vote block on the remedy of what to do about it, right? There was a 4-vote block. Scalia, Kennedy, Thomas Alito said get rid of the entire thing. And you have a 2-vote block from Ginsburg saying uphold it all. You had a 3 in the middle. So when you don't have 5, you take the most narrow position. It's not that 4 beats 3. 4 never beats 3. 5 beats 3, but 4 doesn't beat 3. But the 3 most narrow, that controls. I'll give you an even better example.
I'm
What
sorry,
if,
Josh?
yeah.
4 doesn't beat 3 if 2 are disqualified or sitting out?
Well, if they're disqualified, well, a 7-vote block is even trickier. So what's the presidential value of the Fisher case, right? This past summer, we had a decision involving the University of Texas at Austin. It was a 4-3 decision. I don't think there's any presidential weight. There's not 5. I don't. But I'll give you a better example. What if it's a 4-1-4, right? For example, there's an affirmative action case called Bakke. You'll read it later this term. 4 votes said one thing, 4 votes said another, and one guy in the middle was kind of, the 1 vote controls. So unless you get to 5, the rule is called the Marx rule. You take the most narrow position. It's baffling, right? But I think in response to your question, I think it's a fair question. We have 5 votes for commerce. You have 5 votes for necessary and proper. I think that's a valid precedent. Brandon, I think your hand was up also.
I think this is a related question. Under what purported power did Congress pass Medicare and Social Security?
Spending power, right? Those are all taxes on payroll, right? I mean, I'm assuming you've all worked at some point in your lives, right? When you get your paycheck, it lists the various deductions. It's a payroll tax. So it's clearly designed as a taxing program. So there's no problem, right? This is a point Ginsburg makes. If Congress wanted to just enact single payer and just impose a 15% tax on every salary in the country to pay for health care, there's little doubt they could do that under modern precedent. So ironically, they chose she says it's free market, it's not. But it's a not universal plan, less centralized. And that, she says, ran afoul. So if they just imposed a payroll tax on people to pay for health insurance, that would have been fine. What else? What else? Yes.
So what's the difference? I guess what's the difference between like we're required as drivers of vehicles to have auto insurance?
So which jurisdiction requires you to have auto
Texas.
insurance? Is that a
So-
federal or a state jurisdiction?
State.
Ah.
So it would be up to the states
Because
to
it's
have
part of their what power?
the police power.
Bingo. So I'm paying attention. Very good.
But you
This-
also don't have to, if you don't own a car, you don't have to.
Exactly. Oh, you got my next point out. Right. So under the state police power, the state has the sovereign authority to command you to buy insurance if you're driving. But if you're not driving, they can't make you buy auto insurance. It would make no sense. with the Obamacare mandate, by virtue of being alive, you were subject to the mandate. Now, there were exceptions for Native Americans and for prisoners and other people, but virtually everyone was subject to this mandate, and that had never been done before. But yeah, the car insurance mandate only applies if you're driving a vehicle.
So what about Social Security?
Exactly, on public roads, if you're driving on your farm, you don't have to. So Social Security is a payroll tax. The taxing power is broader than the commerce power, right? Congress can tax local activity regardless of its affecting interstate commerce. So Congress can tax the sale of whiskey, they can tax the sale of lottery tickets locally, but they can't make you buy something, right? Where is it a tax and where is it a regulation? What the court said here was, this is not a tax, it's a regulation, but we'll save as a tax anyway.
So, I wrote down, Justice Roberts held that Congress's use of the taxing clause to encourage buying something is by contrast not new. Tax incentives already promote, for example, purchasing homes and professional education.
Right.
So is that like him kind of backing into, well, this is better than just raising taxes across the board for everyone if you play ball with this initiative?
Yeah, it's a
you get
policy
tax
thing,
break.
right? I mean, you can either buy insurance and get something valuable or pay the tax penalty. But I think the point you're getting at is Congress uses tax incentives a lot, right? They say that if you buy solar panels, you'll get a tax rebate. The flip side to that is if you don't buy the panels, you pay more taxes. So what Ginsburg says is, look, we penalize people all the time for not doing stuff, right? If you don't buy solar panels, you have a higher tax bill. If you don't buy insurance, you have a higher tax bill. That's what Ginsburg argues.
Right. And I know that my commentary before didn't meet your approval, but what I was really kind of getting at
It was the
that
language, not the content.
was that Robert sold me more or less on the tax.
A bill of goods, or what did he sell?
I was kind of getting what he was putting down, but like it's got to be like there's got to be some incentive to the person that's paying the tax.
Right, and that's what Roberts is saying. It's
Yeah.
always going to be affordable, right?
Yeah.
The way that the Obamacare law was structured is that your mandate has to be less than the cost of insurance, right? Because let's say, I'll give you an example. Let's say the cost of insurance is $500 and your penalty is $1,000. Who in their right mind would pay $1,000 for nothing over $500 for some health insurance? So by statute, the penalty is capped. And that actually satisfies Roberts more so that it's not a penalty. Brittany?
Except that wasn't the case. I've paid the mandate 2 years in a row now because my bill is less than the Obamacare they offer.
So
The board said it was-
it's based on, I think, the middle silver plan in your district. It has to be less. Talk out to us. It should be. It might be close, but it's less.
Okay.
It's not a good deal. But I do have a lot of students who take the penalty. There's another hand somewhere. Anyone else? Yeah.
I don't mind.
Oh, Brandon. Yeah.
Is the federal income tax an apportioned tax?
Well, the federal income tax was done by amendment. So this is actually a good story. The Supreme Court ruled in a case that so originally Congress tried to impose an income tax by statute. And the Supreme Court struck it down. They said, you can't do that because it's not apportioned. So then they came back with an amendment to the Constitution which allows it. Carl?
Yeah. I wanted to talk a little bit about the commerce, even
Sure.
though that was struck down, it was pretty close. And I believe I heard you say you weren't quite so sure it should have been, they may have had a little bit of teeth there on that one.
Yeah, because I think what Robert's opinion does, it doesn't really cite Raich very much, does it? It goes, see, I think Lopez and Morrison had one opinion, Raich went the other way, and then Obamacare pulled it back to Lopez and Morrison. So I think that Roberts' opinion is very much consistent with Rehnquist. He clerked for Rehnquist. I don't think it's consistent with Raich and Stevens. I mean, if you look at how Stevens defined commerce, an economic activity from Webster's Third Dictionary, it's basically every facet of human life. Under Stevens' definition in Raich, I think self-insurance would have been an economic activity, but not under Lopez and Rehnquist.
But see, that's what I have a problem with is self-insurance. I mean, insurance, just in its nature, is, you know, you're purchasing a product to transfer risk, which shows your financial wherewithal and responsibility. If you're self-insuring, that should mean that you're then sticking money away or putting it into your own savings account for that purpose. But that's not what's occurring. You know, the
So-
people just aren't doing anything at all,
So,
so.
this is a point that Ginsburg makes, I think, quite well. Does Congress have to specify with certainty the way things work, or they can just use broad strokes, the rational basis test, right? Ginsburg says it doesn't have to be, precise. It can be, Congress thinks as a general matter, people who self-insure are probably saving money away for themselves. They don't have to, but they could. And Ginsburg says that's enough. That's a rational basis to proceed. Roberts doesn't buy that. He says you need to have a little more specificity.
I don't think it's a rational conclusion though, because why are we having this discussion to begin with then? If it
So
was a
yeah.
rational
So the word
conclusion-
rational, we haven't done the rational basis test yet, but the word rational, put the word imaginary, right, in its place. It doesn't mean logical. It means in any bizarre universe, could this be the answer? And if the answer is yes, that's possible, right? Is it even feasible that you have all these farmers growing small amounts of wheat that are going to screw up the interstate market? Of course not, it's insane. But under the rational basis test, you don't need reality. You need a figment of your imagination.
With that line of thinking though, could the government not, or the Congress not say, hey, we're gonna start limiting, people from taking more than 2 weeks of vacation from their job, and if you take more than 2, we're gonna fine you or penalize you, which essentially would be a tax, because taking more than 2 weeks impacts
National
commerce.
economy.
So you're sitting at home for 1 additional week, you're screwing up with commerce, and you're not doing anything.
Well, I think the better example is people who take too much vacation are penalized, right? Because they're not contributing enough. Basically, staying home from work, being unemployed, there's a tax on the unemployed, right?
Right.
That by sitting home and not working, we're going to tax you. I think that's what you're getting at, right?
Right. You're not contributing.
Well, under the Roberts opinion, the staying at home part would be inactivity. And because it's not within a class of activities, it's not an economic activity, Congress can't reach it. And indeed, I think making someone go to work might be a form of slavery. I mean, somewhat facetious, but it might be 13th Amendment issue by making someone go to work. This is true. Other questions? All right, so let me summarize a bit, and I'll give you something useful to take home with you. This decision, the NFIB or Sebelius, is probably one of the most important decisions of at least the last 10, 20 years, maybe even longer, because it represents the Supreme Court blinking in the political process. The Roberts opinion, I've come to terms with the saving insurrection. It took me 3 or 4 years, but I've come to terms with it. I can't come to terms with the direct tax argument. I can't. It's complete bunk. It's not real. It's fake law. If I have that understanding, you have to recognize that this decision, though, was the chief's effort to give a bone to both directions. He wanted to give the conservative something, I'll give you some commerce clause, give them necessary and proper clause. Give liberal something, you have health care, right? And Roberts keeps saying it's not my job to judge the wisdom, that's for the American people to decide. It's a little weird seeing that, right? Why do you even write that? Because Roberts probably hated this law, he's a conservative guy. But he has this streak of judicial minimalism that pervades his opinion. So what's the upshot? Where does the Commerce Clause stand today? If you ask me, I think we're closer today to Lopez and Morrison than to Raich, right? I think we're back to where Lopez and Morrison was. I think Gorsuch's replacement of Scalia makes that a sure bet. If President Trump can nominate 1 more justice, or maybe 2, that's a very sure bet. Where are we in necessary and proper? For the first time, really, in years, the court found that a federal law was not proper. Even a law that was part of a very regulated scheme. I've raised necessary and proper arguments elsewhere. I haven't seen many other court strikes that down, but it's there. Where are we on the taxing power? Well, oddly enough, we're exactly where we started from. The Supreme Court has long held that Congress can tax local activity. But now Congress has a new incentive, right? They don't have to call it a tax in the statute because Congress can bail them out. The court can bail them out. So even if Congress avoids the political cost of calling something a tax in their statute, they can be confident that if push comes to shove, the Supreme Court will rewrite the statute. Where do we stand on the spending clause? I think this is an important question, right? To date, I think 20-something states have not expanded Medicaid. They probably will at some point, but they haven't. And that's created this weird disparity in funding. So now when Congress seeks to put conditions on funding, they need to be aware, how much are we withdrawing? Is there actually a limit that may go too far? That is, I think, a decent enough summary of the case, and also a good vignette of the personalities of the justices. Anything on your minds you want to ask? Yes.
What happens to the funds that the other 20 states aren't picking up?
I'm sorry?
What happens to the funds from Medicaid that the other states?
So there's an irony, right? Texas, you guys are paying for the Medicaid expansion, all the states but yours, right? So Texans are paying the tax for it, and Texans are not receiving the health care. So there's a disparity. Yeah.
I read Ginsburg's dissenting opinion to be particularly snarky. Like, it seemed like she was.
You know what SNARK stands for? Snide remark.
Okay.
Why do you think it was snarky?
Well, I mean, she used like a lot of like animated language.
Well, in some places it wasn't dissent. It was in some parts concurring, in some parts dissenting.
Right.
It's
But
to keep
she-
you awake.
Right.
Keep you awake. He knows you're eating.
Yeah, but like her dissent towards his opinions on the Commerce Clause.
Well,
It
if
seems
you
like-
think she's snarky, wait till you read some Scalia, some vintage Scalia. Ginsburg's tame. She doesn't even hold a candle to Nino. It's like, it's like being chastised like by your grandma. It's nice, but it's Scalia's like guns blazing.
But it almost seemed as though she had maybe like formed that opinion prior to his actual ruling, because she kind of like switched gears a little bit after.
Well, if you give credence to the theory that the votes were in flux, she may have drafted the opinion early on, which is possible. Carla.
A little bit off to the side, but while I'm reading this, I'm wondering, so what is that process? Because if they're referring to each other, well, who puts theirs out first? And then, okay, now attack me, and then.
So I mean, this is going deep into the weeds, but as far as I can tell, Roberts was somewhat on the fence, so both the conservatives and liberals are drafting their own opinions. And they didn't have to circulate to everyone, they may have kept some stuff behind. And at some point, Roberts circulated his opinion, and the others said, okay, that's what we're going to do in response. No one else? Well, thank you very much for your attention. I'll see you all on Tuesday.
So 1 or 2 o'clock?
Well, it's their second semester.
So 1 o'clock?
Yes.